First of all, let us see what is copyright. Copyright is a type of intellectual property rights IPR. Copyright is an intellectual right given by the law to creators of literary, dramatic, musical, and artistic works and producers of cinematograph films and sound recordings. That is, copyright is a form of intellectual property that protects original literary, dramatic, musical, and artistic works, as well as layouts or typographical arrangements of published work, sound recordings, film, and broadcast. Copyright also covers the architecture and computer software or program. That is, copyright also applies to architectural works and computer program or software. In fact, copyright is a bundle of rights including inter alia, rights of reproduction, communication to the public, adaptation and translation of the work. Actually, copyright gives the creator of the work the exclusive rights to copy, license, rent, lend, perform, show the work to the public, make an adaptation of the work, or translate a work. Okay. Subsequently, the question that comes to our mind is, what works are commonly protected by copyright? Right? So here is the answer. Works commonly protected by copyright include literary works such as novels, poems, plays, reference works, newspaper articles, computer programs, databases, films, musical compositions, choreography, artistic works such as paintings, drawings, photographs and sculpture, architecture and advertisements, maps and technical drawings. So broadly speaking, these are the works commonly protected by copyright throughout the world. Okay. Why should copyright be protected? Copyright ensures certain minimum safeguards of the rights of the authors over their creations, thereby protecting and rewarding creativity. Any civilized society cannot afford to ignore the basic requirement of encouraging the creativity, which is being the keystone of progress. Economic and social development of a society is dependent on creativity. So actually, the creativity being the keystone of progress, no civilized society can afford to ignore the basic requirement of encouraging the same. Economic and social development of society is dependent on creativity. Okay. Furthermore, why should copyright be protected? The protection provided by copyright to the efforts of writers, artists, designers, dramatists, musicians, architects, and producers of sound recordings, cinematograph films, and computer software creates an atmosphere conducive to creativity, which induces them to create more and motivates others to create. That means because of the protection provided by copyright, creators are getting incentives in the form of recognition and fair economic rewards. This in turn induces the creators to create more and also motivates others to create. Okay. Furthermore, copyright protects only the expression of ideas and not ideas themselves. Copyright protection extends only to expressions and not to ideas, procedures, methods of operation, or mathematical concepts as such. Actually, copyright does not provide facts, ideas, systems, or methods of operation, although it protects the expression of ideas. That is, the way these things are expressed. Okay? Copyright does not protect names, titles, slogans, or short phrases. In some cases, these things may be protected as trademarks. So that is, copyright does not ordinarily protect titles by themselves or names, short word combinations, slogans, short phrases, methods, plots, or factual information. Copyright does not protect ideas or concepts. To get the protection of copyright, a work must be original. Okay? Copyright Act 1957. The Copyright Act 1957 governs the law pertaining to copyright in India. The Copyright Act 1957 protects original literary, dramatic, musical, and artistic works, and cinematograph films and sound recordings from unauthorized users. This is the scope of protection in the Copyright Act 1957. The object of copyright law is to motivate the new ideas of the authors, composers, painters, and artists, and to create the original work without the fear of exploitation of their work or matter. Actually, the copyright law is to guarantee authors, musicians, painters, designers, and other creative individuals the right to their creative interpretation and to enable others to openly develop upon the concepts and knowledge made available by a work. As the copyright laws extend economic benefits to authorship, they encourage writing original works. Actually, the Copyright Act 1957 provides both economic and moral rights to authors. We will see these two rights a bit later in this video. Okay. Next, we will see the term of copyright. Copyright is protected for a limited period of time. The general rule is that copyright lasts for 60 years. In the case of original literary, dramatic, musical, and artistic works, the 60-year period is counted from the year following the death of the author. Where there are multiple authors, the term is 60 years post the death of the last author. Okay. In the case of cinematograph films, sound recordings, photographs, posthumous publications, anonymous and pseudonymous publications, work of government and works of international organizations, the 60-year period is counted from the date of publication. In case of unpublished cinematograph films, photographs and computer programs, the copyright subsides up to 60 years from the year in which the original work was created. Okay. Now let us see copyright notice. It is highly advisable that a work protected by copyright contains a copyright notice. A copyright notice generally contains the following elements. Number one, the symbol of copyright. That is a circled capital letter C. That is a letter C in a circle. Or the word copyright. Or the abbreviation COPR. Okay. Number two, the year of first publication of the work. And number three, the name of the owner of copyright in the work. Examples are given here. As mentioned earlier, the Copyright Act provides both economic and moral rights to authors. Here we will see these two rights. First of all, economic rights of copyright owner. So what is economic right? So any right that yields or payoffs the owner monetarily is said to be economic right. Okay. Economic rights allow right owners to derive a financial reward from the use of their works by others. What are the rights? Right to reproduce the work. Reproduction is an act of copying from the previously finished works or giving it a differential form by adding, editing, or modifying the same. So in short, it means right to copy. Okay. Right to distribute in market. Similar to the right of reproduction, the owner of the copyrighted work also has a right to distribute in the market and make money out of it. The act of distribution may be in the form of sale, lending for free, or for a consideration, rental, or free distribution by the way of gift. Right to communicate to the public. It means letting or making the product or work available to the public by way of broadcasting, simulcasting or webcasting. Okay. Right to adaptation. So right of adaptation, the copyright owner has a right to convert, alter, rearrange a copyrighted work. Then, right to translate. The owner of the copyrighted work has a right to translate his or her work to any other languages. Okay. Now we will see the moral rights of a copyright owner. The moral rights of the copyright owner has been provided under Section 57 of the Principal Act that encompasses three basic moral rights. Model rights allow authors and creators to take certain actions to preserve and protect their link with their work. What are the different types of model rights? Right of paternity. This is the right of an owner of copyright to claim and prevent others to claim the ownership of his or her copyrighted work. Okay. Right of integrity. This is right of the owner of the copyright to protect the reputation of his or her own work from exploitation. Right to retraction. After submitting a copyright takedown request, a copyright owner may change their mind or realize they have misidentified content. When this happens, the copyright owner can retract their claim of copyright infringement. Okay? Exceptions to infringement under Copyright Act. The Copyright Act 1957 provides for certain exceptions to infringement of copyright under Section 52. In order to protect the interest of users, some exemptions have been prescribed in respect of specific uses of works enjoying copyright. Some of the exemptions are the uses of the work for the purpose of research or private study, for criticism or review, for reporting current events in connection with judicial proceeding, performance by an amateur club or society if the performance is given to a non-paying audience, and the making of sound recordings of literary, dramatic or musical works under certain conditions. Okay. Now let us see copyright protection for computer software. Computer software or program can be registered as a literary work. As per Section 2(o) of the Copyright Act 1957, literary work includes computer programs, tables, and compilations, including computer databases. The Copyright Act 1957 contains provisions that provide the copyright protection for computer software. Okay. Source code and object code have also to be supplied along with the application of registration of copyright for software products. The source code contains information that made it easier for a programmer to write or understand the program, isn't it? Actually, the source code and object code are different. They are distinct. However, the Copyright Office considers the source code and object code as equivalent for purposes of registration. Okay? In this regard, copyright for website. A website contains several works such as literary works, artistic works, photographs, etc., sound recordings, video clips, cinematograph films, and broadcastings, and computer software too. Therefore, a separate application has to be filed for registration of all these works. The component parts of website can be in different form of digital files as mentioned here. Applicant is required to submit a separate application for each component work or content appearing on a website. Okay. In addition, Copyright law does not protect domain names. The Internet Corporation for Assigned Names and Numbers has assumed the responsibility for domain name system management. This organization administers the assigning of domain names. So copyright law does not protect domain names. Okay. Now we will see the infringement of copyrighted software briefly. Infringement of copyrighted software is called software piracy. Software piracy is reproduction, distribution, or use of a software product without the expressed permission of its author. Software piracy is theft, stealing someone else's original idea and product. Some examples of infringement of copyrighted software: downloading the software or programs from the web, the end users using the unlicensed software on their systems, the sale of illegal duplicate copies of software. These are some examples of the infringement of copyrighted software. Okay. Registration of a work under the Copyright Act. The procedure for registration of a work under the Copyright Act 1957, the guidelines regarding registration of a work under the Copyright Act and related information can be found at copyright.gov.in. So in this website, you can find the guidelines and procedure for registration of your work under the Copyright Act and related information. Okay. I have now come to the end of this video. Let me now summarize what I explained about copyright. This video helps you all to briefly know about what is copyright, why should copyright be protected, copyright protection, the main provisions of the Copyright Act 1957, rights of copyright owners, term of copyright, copyright notice, and exceptions to infringement under the Copyright Act. Also, this video provides a good insight into copyright protection for computer software and websites, and also infringement of copyrighted software. Furthermore, this video gives some idea about how to register a work under the Copyright Act. Okay.